You see, all of this comes on the back of, you said these were observations. There was a written order just a week before that in the Teesta Settlement case, where the judges say, people keep the, and Teesta Settlement was a co-petitioner in the case. The judges say people kept the pot boiling for ulterior design, and all those involved in this abuse of process should be in the dock and proceeded against as per law. This is in reference to the Gujarat 2002 case that she had raised. And a day later, she gets arrested because the sense is the judges in a case where I've gone as a petitioner is now virtually telling, not only dismissing the petition, but also virtually encouraging the police to go and arrest her, which is exactly what happened a day later.
This is very unfortunate. And on this, I have heard something said by Justice Lacour, one of the retired judges. And I entirely endorse his views. The judges should make it very clear whether they actually meant the arrest of Teesta. This kind of observation in a written judgment is very, very unfortunate, uncalled for, and without a precedent.
So you're making a distinction between the Teesta Settlement case, where you're saying because it was part of the written order, you are troubled by it. But in the case of Nupur Sharma, you're saying these are mere observations. They should not be seen, therefore, as judicial overreach. Am I correct?
Yes.
Yes, Dr. Singhvi.
I think your own example illustrates the vital difference. They were not only part of a written order, it's not merely the writing which matters. It was an essential part of the judgment. It's a 50-70 page judgment. An essential part is the para you read out. Now the reason it is objectionable is the following. First of all, the judges have a right to dismiss the claim filed by Mrs. Zakri. They have the right to say that it is unmeritorious. This para, A, is part of the main reasoning. It is not an observation. B, it goes far beyond by attributing motives to the initiation of the complaint. And C is the most important. Everybody knows it's the best kept, least kept secret that the government is raring to go at the leash to go against this person. These observations give the government the license to unleash a blitzkrieg of action against this person. The least the judges should then have done, and that's my fourth point, is to issue a clarification. They should have said, this para is not intended to be a license this way or that way about me going and arresting him or him arresting me.
You know, but Mr. Saikia, and you're with Advocate General appearing for a government, part of the problem is the sense that these are seen to be increasingly political cases. And the moment judges enter and observe, make observations on political cases or pass written orders, it's a minefield out there. In a society that is polarized, the judges seem to be also getting trapped in the polarization that takes place. So on Teesta Settlement, whatever our views on her are, tend to influence how we see the judgment. Similarly on Nupur Sharma.
That is the problem. Nowadays, it is the problem creates with the reporting. Now the deliberations, earlier the final judgment is in the news. But nowadays the deliberations between the judges and the lawyers, it comes into the newspaper rather than the judgment itself. The judges take lot of questions to the lawyers to go to the root of the matter. If you take the example of during the COVID time, Madras High Court, they have put some questions and ultimately the Madras High Court opined that Election Commission of India is the murderer because of the spike in the COVID cases, which was not the case. In most of the other states, like in Maharashtra, there was no election. But even that, few states were having election, but the judges during the deliberation made a off-the-cuff remark. That is reported much more than what was finally the outcome of the...
No, so are you blaming the media for reporting the off-the-cuff remarks made by judges? Are you saying the media should only report the final judgment?
Exactly, because the judges want to know the mind and the root of the case, to know what exactly is the petitioner. Now, in this case of Nupur Sharma, she wanted that all the cases should be together. In that case, certain remarks were passed to know what exactly she was doing. And in that outcome, certain off-the-cuff remarks were made. And that was highlighted, and that is why I do not want to enter into the chain of the reactions, counter-reactions, overreactions, all these things. But the thing is that end of the day, we have to go by the pleadings and what was argued.